Good morning, everyone.
Morning.
We are going to
Hello, good morning. Hello,
we are
Shapad.
going to start the second session of the day, uh, which which is so very important in these days when we have lots of patients coming into ICUs and with the load increasing day by day. So we need to decide about withholding treatment and withdrawing life support. So we have a very good panel of speakers, and I would like to first introduce the chairpersons, Dr. Sheila Maitra. Madam is the professor of anesthesia and critical care in Tata Memorial Hospital, Mumbai, and she is also the chair of the intensive and critical care medicine committee. The second chairperson is Dr. Shabbar Jod. Dr. Shabbar Jod is a very well-known intensivist of Rajasthan. Currently, he heads the critical care and emergency medicine in Manglam Medicity. I'd like to hand over to the chairperson so that they can carry on with the session.
Good morning, everybody. Welcome to this very interesting session. I'm delighted to be chairing this session because this is a topic which is very dear to my heart, and we are very fortunate to have absolute experts in the field who have done pioneering work, sharing their experiences and giving us update on this topic. So without any delay, I'll move on to the first talk by Dr. Roop Gursahani. He is a consultant neurologist at the PD Hinduja Hospital and has done a lot of work with advanced directives and various things. I won't go into details in the interest of time, but I find him to be one of the most passionate people in this area and one of the most humble and simple physicians I have met. He's going to be talking about something that quite a provocative title for his talk, India, Not a Place to Die in. So over to you, Dr. Roop Gursahani. I'm sure there'll be a lot of questions. I request all the attendees to please type their questions in the chat. Over to you, Dr. Roop Gursahani.
Hello, I am Roop Gursahani, and I'm going to be speaking to you on a topic that I have covered some time ago as well. India, not a country to die in. And whether you see an exclamation mark there or a question mark, to some extent depends on your perspective. Let me begin by thanking Anjum and Naveen for inviting me to speak to you today. My journey on this issue began in 2011. And this was the judgment that concerned Aruna Shanbag. To some extent, her personal tragedy has faded into the background, but for anybody who's interested, I strongly recommend that you look at the Wikipedia entry on her. And this forgotten judgment actually decriminalized the procedures of withholding and withdrawing life support treatment at the end of life. In 2015, the Indian National Associations of Neurologists, Intensivists, and Palliative Care Physicians came together to form a multi-specialty task force, ELICIT, End of Life Care in India Task Force. And I'm grateful to Dr. Raj Mani and Dr. Nagesh Sinha for their leadership, mentorship, and spirited friendship. It has been an exhilarating journey so far with the two of them. Towards the end of 2015, Dr. Mani and I jointly wrote up a survey of end-of-life care in India and compared it with the situation elsewhere. So, India, not a country to die in. The title came from a blog post by a lady called Jo Chopra about the difficulties her family faced when they decided to let an older relative with a bad stroke pass away in peace and dignity at home. Reading through the piece that we wrote, I think it has aged well, but our position has changed on the need for an overarching end-of-life care legislation. In 2010 and 2015, The Economist with the Lien Foundation produced two superb surveys of end-of-life and palliative care across the world. And as you can imagine, India was pretty low down. But it is more instructive to follow the leader. The United Kingdom was at the top in both surveys. And this in spite of not being the wealthiest nation or even spending the most on these services. The first reason has to be with being the country of Hurricane Cecily. For all of us who do palliative care, you must read her short bio on the Cecily Saunders Institute website. And she really was called Hurricane Cecily. Obviously a remarkable person. And the other has to do with the National Health Service of the United Kingdom. And that's where I'm heading to next. Sorry, I missed out a little point. For anybody who's interested, the latest quality of death and dying survey of 2020 and 2021 has just been published. And you can look for it. I think it's just out. Dr. Sushma Bhatnagar is one of the co-authors. And interestingly, Taiwan is number 3 in the world on quality of death and dying. Right. So what is it to have a good death? It means palliative care at home and hospice admission when needed to ensure an almost pain and symptom-free death. Information as wanted and needed conveyed sensitively to the patient and her family with due regard to autonomy and choices. An actionable medical, advanced medical directive where values and wishes for end-of-life care are discussed and recorded. Best interest decision making, so that if unable to communicate the issues of ethics, law, and medicine, would be addressed expeditiously by a designated legal agency, and all these services delivered by public agencies. And from an individual patient's perspective, this is the United Kingdom ideal. It may not always happen, but it is supposed to. From a system's perspective, what does it take to get adequate palliative care? Palliative care, first of all, has to be integrated into universal healthcare through either a healthcare system or an insurance system. And I cannot highlight this enough, that it is universal healthcare, and the National Health System, NHS, is a universal healthcare system. That then should have a comprehensive national action plan for palliative care, which ensures there's an adequate supply of palliative care professionals from all streams, not just specialists, but also volunteers with interdisciplinary care possible. There have to be clear criteria for accessing palliative care, and there has to be easy access to palliative care. And where are we in India? Well, we do not have universal health care, and we are unlikely to get it for a fairly long time. So we have a problem of both low demand and low supply. And in that sense, perhaps there's an easier solution. It's called Say's law. Supply creates its own demand. And we have seen it actually happen. Now, this is assuming that, except for villagers in Kerala who actually get better palliative care than even the metro cities, the rest of us probably will not have access to decent palliative care. So how do healthcare workers ensure that we can fulfill our duty to patients who will inevitably die on our watch? Can we follow the ethically, morally, emotionally, appropriate or right path for our patients, or are we going to be hamstrung by our legal system? Now, I am an optimist, and I will see the glass as half full. The half full part of the glass is the 2018 Common Cause verdict, which was originally filed as a PIL way back in 2005. Dr. Mani and the ISCCM were part of this, but for illicit, this was a stroke of supreme good luck from the universe. And together with Vidhi legal policy, we have been working on making this possible in practice. So this judgment is part of a triptych of judgments with which the Supreme Court finally brought the liberty of our constitution from the political to the personal space, with privacy first, then health autonomy, but also following on with sexual freedom. And these were judgments that were delivered largely by the same judges in a period of almost about 13 months. So although this judgment is long, almost about 500 plus pages, there are some operative aspects. And if someone explicitly forbids a specific treatment or intervention, and a valid advance medical directive is such an instruction, then going against that direction is liable to legal action. Since this has been stated by the Supreme Court, this is the law of the land, and there should be no ambiguity about that. Elsewhere in the world, the maximum Elsewhere in the world, the maximum litigation around the end of life is for wrongful life, for resuscitation carried out against the wishes of the patient and family. So, in late 2019, Dr. Mani, Dhwani, and I were part of the team that worked on the Do Not Attempt Resuscitation document for the ICMR Bioethics Department. This was published in April 2020, and this has a form you can use as well as an algorithm for working it. And let me show you. Yes. Remember that both of these are put out by the premier medical think tank of the Indian government, telling you that this is good medical practice. So this is a form that you can actually use. Now, putting this in the context of the 2018 judgment makes it crystal clear that the DNAR orders are valid, enforceable, and no one can deny them without valid and documented reasons. In practice, we find that when we are discussing foregoing life-sustaining treatment with the family, signing this instrument is in a sense a crossing of an emotional Rubicon for the family. So I strongly recommend that we do not underestimate the value of this simple form and the simple order. Now, if you do a Google search for living wills in India, you will see all kinds of documents, and I have seen people literally making up their own. Sometime in 2019, Naveen, Dhwani, and I and others working under the guidance of Dr. Raj Gopal modified and elaborated the basic Pallium India living will in the context of the 2018 judgment. This is available on the IAPC website. It's also on the Pallium India and Vidhi websites. It is a little different from advanced medical directives that you may see internationally. It includes the nomination of healthcare power of attorney, but it also adds the requirement of 3 independent doctors confirming medical futility before proceeding with foregoing life support. The Supreme Court also requires the advanced medical directive to be signed in the presence of a judicial magistrate. And obviously, this makes this instrument a little difficult, but people are actually taking the trouble to do this much. And my sense is that once more people actually take the trouble of doing this, whether they go as this couple went through the district judge, or perhaps in a sense of public spiritedness going through the High Court and getting it clarified for the state as a whole, I think this process will then become easier. And it is important that this will have to be done state by state. And basically, you have to ask judicial magistrates to do their duty of countersigning this, which is not, at the moment, is not totally easy. But making an AMD using this draft is actually very simple. Even if the document is not signed before the JMFC, but if it is made known and accepted by the family, it makes for a major step. But the point I want to make that suggesting, counseling, completing advanced medical directives should be recognized as part of the palliative care workers' job in the same way that vaccination is a standard responsibility of pediatricians. In 2014, the IAPC, the ISCCM put together an end-of-life care pathway. The original document has more than 10 steps, but the essentials are quite simple. But you still need forms and documents to make this work. Now, there are 2 resources that you can use. Blue Maple is the Manipal Group's blueprint, which Naveen, together with inputs from us and a wide range of people from within Manipal, put together. It is registered for their use, but I guess you can write to him for a copy and permissions. The AIMS guidance is somewhat simpler, is available on their website, and well, AIMS is a statutory body. There are enough differences between the two that you can actually mix and match and figure out what you want to use. For all of us who practice in large hospitals, there is enough here for us to prepare an end-of-life care policy for your own hospital. And this, remember, is a requirement for NABH accreditation. In fact, we were part of a FICCI document that makes this simplicity explicit, and it converts it into basically just 3 steps. Ideally, the due process has to be backed by a hospital policy. First, the treating team has to confirm a consensus of utility amongst the involved consultants. Obviously, if the patient is competent, then the patient has to decide. If there is an advanced medical directive, then you use that. Otherwise, then you go on to the surrogates. In the question of the surrogates, you have to confirm a hierarchy, and I'll be speaking about that, confirm consensus amongst them, and then complete documentation with a detailed note on the clinical condition to be signed by the surrogates and the 3 consultants with a post facto audit. So 3 steps: treating team, surrogate decision makers, documentation. And but there is one specific nugget in the AIMS website that in the AIMS document that I need to highlight. Now, surrogate decision making needs surrogates, right? So who's a valid surrogate when the patient has not specified this? If there is an advanced medical directive and this is listed, then life is simple for us. But if not, then what? So the AIMS document, and I think I have to thank Dhwani for this, it lists a surrogate hierarchy, and we need to use this on a regular basis since it is both a fairly evolved instrument and also detailed enough to take into account the various flavors of our Indian social situation. One simple example, think of an elderly man with 2 marriages, one legal, the other actual. How do you sort this out? Well, this will give you some guidance. I remember the picture of, one of our former railway ministers who actually ended up in this situation. Please remember that this is a workable instrument. If we work it and use it, eventually the lawyers and judges will come around to accepting that this is valid. I need to make this point very clear. The legal system looks to us to make valid pathways for this decision making, and it is not the other way around. They do not know the nitty-gritty. And if there are valid instruments or processes that medical bodies have consensually evolved and are using, they will become the law. Again and again, I hear senior people from within our profession saying, this is illegal, this is illegal. Modi has not told me to do this. That is absolute rubbish. I'm going to finish by giving some current details of the brain death issue, since that is currently a work in progress. Death by neurologic criteria is recognized across the world, and there has been a World Brain Death Project with published literature as of last year. The consensus is that determining brain death has enough science behind it for us to be able to set due process. Each country needs to set this in crystal clear fashion when this has to be done for organ donation because of potential for actual and perceived misuse. When it is not for organ donation, then determining brain death is just a clinical job or determination, and we must get on with it, taking the family into confidence, but without their permission if need be. And this depends on context. If you are in a private setup and the family is paying, well, he who pays the piper calls the tune. If you are in a public setup, you have the responsibility of stewarding scarce resources. And if you are in Kerala, Karnataka, or Gujarat, you're protected by a government order. What if you are in a private setup and this is being paid by insurance? Remember that you have to be careful not to be caught in between. There has been some movement towards having death by neurologic criteria recognized as part of the births and deaths registration process, and issuing an order from the union government for the whole country is in process, but that will take some time to happen. Till then, please remember that the only litigation on the end of life process so far in India has been this consumer court judgment where a hospital was fined rupees 5 lakhs for keeping a brain dead boy on the ventilator. There's yet another project now on the horizon, the donation after cardiac death, and Illicit is involved with that too, with colleagues from the transplant community, and perhaps we can elaborate that in the panel discussion. So let me repeat this particular point. We have these 4 resources, the AIMS guidelines, Manipal's Blue Maple, the Advanced Medical Directive, and the DNAR document. All of these have constitutional backing from the 2018 judgment. If you use them, because they have a considered body of national medical legal opinion backing them, you are protected. If enough of us use them systematically, they will become the law. Illicit has been a small part of making this happen. And let me repeat and come back to the glass half full analogy. This is enough for us to get on with our end-of-life care job without getting bogged down in waiting for a full end-of-life care law. No country has a detailed omnibus law. All democracies seem to do this piecemeal, working each part of this tapestry, one part of it at a time, as their background and their culture permit. My email is out here, so is my mobile. I'm happy to answer queries from you on specific situations and problems that you may face. And I know the other members of Illicit also will second me on that. Thank you.
Thank you very much, Dr. Gursani, for a very interesting and thought-provoking talk. We'll move on to the next speaker, Dr. R.K. Mani. Dr. Mani really needs no introduction, a very close friend and fellow intensivist. He is the Director of Clinical Services at the hospital in at the Ashoda Hospital in Kaushambi in Ghaziabad. He heads the pulmonology critical care over there. He's also part of the end-of-life care task force. Professor Dr. Mani was the previous president of the Indian Society of Critical Care Medicine, and he's also been the editor of the Indian Journal of Critical Care Medicine. His area of interest is end-of-life care, respiratory care, and of sepsis. And he's been extensively involved in a lot of pioneering work on end-of-life care. I was closely associated with him when he was chairing the guidelines that we came out with on the joint guidelines with IAPC and IACCM on end-of-life care guidelines for India. And he's also been involved he's implemented the Common Cause guidelines, also the FICCI illicit guidelines, and he's also been involved with the ICMR task force for the definitions and for NAR, and a lot of pioneering work, along with the other members, the speakers on this panel. So he's done extensive work, and I can say that he's so passionate about end-of-life care. He lives, breathes this subject. And very recently, some of you must have seen his invitation by Lancet and the very interesting cartoon that was put out on Twitter on the challenge of identifying death. And let's talk about it. So that was very interesting. So without spending any time, I can go on and on speaking about Dr. Mani, but I'll ask him to speak on his talk today. And that is on a very interesting topic, withdrawing and withholding of life support in the ICU setting. Over to you, Dr. Mani.
Good afternoon. Today we'll discuss the subject of withdrawal and withholding in the Indian ICU. I'll start with this poem, so to speak, written by a 28-weeker newborn. It addresses the doctors. I was born premature 4 months early. You intubated me, put me on a ventilator because you could. And the infant goes on to describe all the interventions that was done on herself and ending in a futile interventions culminating in death. So we must start to ask ourselves, are we to make interventions just because we could? You could does not necessarily mean you must. So this is a process of thinking which we must cultivate as intensivists, because there is the modern dying paradox. Dying has become complicated because of the very medical advances and innovations that have yielded so much of rewarding results since the 1950s, but have also complicated death. Most who can afford die in the ICUs these days in the high income countries, but that has percolated also everywhere, that culture. So what we are witnessing today is medicalized, lonely and impersonal death, which has become burdensome, painful and expensive. And those who cannot afford, and there is inequities across the world accentuated by these very modern medical advances, they have no access to life-saving treatment, and this is the majority. And paradoxically, they too die for want of adequate care, especially palliative care. So the context for withdrawal withholding is that disproportionate medical interventions are rife in the ICUs, as reported by Ruth Piers et al. From Belgium through European surveys. The culture of withdrawal and withholding, and in fact, the culture of adequate care of the dying, varies across the globe, varies within country, varies sometimes even within the same institution, because there are many variables that impact on end-of-life decision-making. You can see in this editorial recently published by Zeng, Bayan, and Curtis in the Intensive Care Medicine, the ecosystem of national culture and national policy impacts on the institutional culture and institutional policy, which in turn impact on the clinicians, the patient and family attitudes and culture and religious beliefs and so on. They interplay with the clinicians' corresponding attitudes, and therefore there is great variability across the globe. And the way people die and grieve have visibly changed since the modern innovations to delay or forestall death. What it used to be before modern medicine was people died as a family event, as a community event in many cultures. But it has now presently come to exclude family and community, who are the ones that are required, needed for the dying patient. And those who cannot afford die badly without palliative care, as I mentioned. In India, many of these ills have been accentuated. In India, we die badly with an undeveloped system of caring, a notable exception being Kerala. We have a poor quality of death rating published in 2015 by the Leon Foundation, and palliative care is given more importance. It's evolving. It's got recognition by the National Health Policy, but strangely it is silent on death and dying. We still do not have a national policy on withdrawal and withholding. So succinctly, if you have to put what withdrawal is, it's a discontinuation of an ongoing life support modality when judged to be non-beneficial and in accordance with the informed choice of the patient or patient representative, surrogate. So withholding is not initiating a life support modality. Withdrawal is, as you can see in the graphic, interrupting an ongoing life support, and withholding is not starting at all. So the data on end-of-life foregoing of life support is sparse, and I can summarize them. The first one was by Kapadia et al. In 2005, a 4-center retrospective cull from SAPS-3 database. Money et al. In 2009, in intensive care medicine, single-center retrospective. Tata Memorial Hospital experience, person communication by Dr. Devatia and Dr. Mayatra. INDICAP's 1 and 2 survey, large-scale point prevalence surveys published in 2012 and again in 2021. And Asian survey reflecting the physician attitudes in 2015. and CMC Valor publication in 2019, a single center retrospective. So formal withdrawal and withholding have been few and far between in India. Indicaps 1 and 2 reveal that 1/3 of the deaths are via LAMA, left against medical advice, euphemistically termed as terminal discharges. So you can see there are large studies, point prevalence studies, majority are private sector, and 1/3 are LAMA, DAMA, discharge on request under conditions of terminal illness, and they are counted as deaths. And in fact, terminal discharges increased from 4.5% to 7.5% of overall admissions in Indicap 2. You can see 70% of deaths are with no form of limitation, and those with limitation are in the form of LAMA. LAMA, in my opinion, is a pernicious practice that violates basic ethical tenets. It's like a washing off of one's hands of the patient when faced with moral or ethical dilemmas. And there's no attempt to address issues of foregoing of life support or dignity in death, only a crude attempt at escaping legal liabilities. It's a very defensive attitude. The patient and families are left to their own devices to face death without palliative care. And in a widely publicized case, it was clear that LAMA is no protection against litigation. If you look at ethics and professionalism briefly, autonomy is a right of choice of the patient, and it's our duty to uphold the autonomy. And it also reflects valuing the patient as a person. Beneficence and non-maleficence are the duties of care of the professional caregiver. Justice and equity are also very important. It is fairness and also ensuring, to the extent possible, equitable distribution or utilization of resources available, and which won't be possible if we indulge in futile care on a large scale. Evidence-based medicine requires that we set goals of care. It's essential tenet. And communication entails that there should be truth-telling, compassionate communication, and transparency. And we must believe and know that best interests of the patient are the only interest and most important and central to all our decision making. And palliation is a patient's right and human right as well. It involves mitigation of all forms of suffering. Foregoing life support in the world is getting easier and easier. Precedents in law in the US since the 70s, the legislation in scores of countries across the world now on foregoing of life support. The copious data of surveys of FLS decisions in ICUs and in the community across the world. An extreme form of respect to autonomy is medical assistance in death made, which is the modern form of active euthanasia, modern word. And it is increasingly acceptable in high-income countries and in several states in the US. Indian data I've mentioned. The data is sparse. Coming to withdrawal and withholding, there's a meta-analysis from several countries. The black bars are withdrawal and gray ones are withholding. You can see in the red boxed publications from India, the withdrawals are very low, very few, whereas in the rest of the world, most of the world, withdrawals are predominating. This is because of our belief that withdrawal and withholding are not equivalent. Although they are ethically equivalent by consensus, we still have a problem in performing withdrawal decisions. You can see in Ethicus 2, which was published 15 years after Ethicus 1, in Europe, in European countries and Israel, these decisions have become increasingly easier and more prevalent. So 90% versus 68% That has been the jump in the last 15 years. And there are fewer and fewer futile CPR. In the most recent publication from Korea, this is online first here, you can see that after the well-dying law that was promulgated in 2018, there has been an improvement in the quality of dying and death score, QODD, in most of the 20-point questionnaire as filled by the caregivers. So you can see it makes a difference to have a national policy and law. In India, we have ethical position statements from the professional societies. This is a collaborative statement in 2014 between Indian Society of Critical Care Medicine, ISCCM, and IAPC, Indian Association of Palliative Care. And this details the process of making an end-of-life decision. The process was updated by Fickey and Elicit together. In this algorithm, you can see that it emphasizes collegiate decision-making between the professionals and then having a shared decision-making process with the patient or with the surrogate, depending upon the patient's capacity. Now, if this also integrates the presence or absence of advanced medical directives. So in this process of communication, there has to be transparency, honesty, truth-telling, and then a mutual understanding which culminates in decision-making and switch over to palliative care. So on institutional basis, there have been policies made by the Manipal group of hospitals in this Blue Maple, very detailed document. And the ICMR, Indian Council of Medical Research, set up a task force which created this document, Consensus Guidelines on Do-Not Attempt Resuscitation. And this is the first statutory body to have published a end-of-life decision-making document only confined to DNAR. And the All India Medical Institute has recently published in 2021 an institutional policy on end-of-life decision-making and palliative care. There is a vexed issue of the law which Dr. Dhwani Mehta will elaborate on. Now, although it's constitutionally valid to withhold and withdraw and to execute an advanced medical directive, it also emphasizes that there is a duty to uphold autonomy and privacy and best interest of the patient. But unfortunately, the procedure prescribed hampers this very practice of these values. Now I'll end with this picture. This shows the dying in dignity of a religious personage who was 102 years old. He was on a ventilator for ILD, and we took a decision in 2 days' time after ventilation to have a withdrawal decision, and this was taken by a consensus process between the caregivers and the followers, and the patient was appropriately withdrawn from the ventilator in the ashram, and he had a mode of death in keeping with his values and wishes as a religious personage. So to conclude, withdrawal, withholding, and DNAR decision making is essential for avoiding non-beneficial treatment burdens in the ICU and in the community. These decisions are based on ethics, patients' rights, and professionalism of the caregivers. The accepted model today is the shared decision-making process. So there is an ecosystem which interacts with the caregivers and the family in making these decisions, so it may enable or hamper, and we must produce reform in the various steps that are needed for end-of-life decision-making. So establishing the constitutional validity of foregoing of life support and advanced medical directive alone has not changed the practice on the ground, because of a restrictive procedure and the lack of drive to reform. Thank you very much for your patient hearing.
Thank you, Dr. Mani, for a very elaborate talk. I'll introduce the next two, third and fourth speakers. Dr. Nagesh Sima is a medical director of Karunashri, Bangalore, and has years of experience and is in the area of interest of specialty communication skills. And the fourth speaker will be Dr. Dhavni Mehta. She is a co-founder of Vidhi Center for Legal Policies. And hello. Dr. Dhavni Mehta, she is a co-founder for Vidhi Center for Legal Policies. Present and her area of interest are health law, medical law, bioethics, medical ethics, and environmental law. So we'll begin with the Dr. Nagesh Sima's talk.
August 15th, 2015 saw the coming together of three national medical associations: the Indian Academy of Neurology, the Indian Association of Palliative Care, and the Indian Society of Critical Care Medicine. The three societies were represented by senior office bearers and concerned members. The purpose was to review the state of end-of-life care in India and the way ahead. It was resolved to form a standing committee, and this was christened as End-of-Life Care in India Task Force, or ELICIT, E-L-I-C-I-T. As the Economist put it a few years ago, dying is inevitable, a good death is not, and Indians seem to die very badly. End-of-life care impacts and is affected by ethics, legislation, and the politics of health and economics. Complex decision-making in illness is combined with individual and family suffering. It is everyone's responsibility. Government, the medical and legal professions, civil society, and ultimately all of us as individuals. Making a good death possible for everyone requires personal and public conversations about death and dying, as well as strengthening the services of palliative care. However, it also requires enabling laws, judicial rulings, and professional medical guidelines. India has only one legislation concerned with end of life, the Human Organ Transplantation Act 1994, and the one amended in 2011, which validated the concept of brain death for the limited purpose of organ donation. In the over 6 years since ELICIT was formed, we were able to prepare and discuss 2 drafts of an end-of-life care legislation. The process involved extensive discussions between doctors from the 3 associations and lawyers in an iterative process. 3 components were defined: validation of patient autonomy and advanced care planning, establishment of due process for resolving of medical futility, including foregoing life support, and a uniform recognition of death, including death by neurological criteria. All these 3 can be accomplished with due safeguards and, more importantly, without any budgetary allocation. We believe that a single overarching central legislation is the quickest route to end-of-life care reform. However, this requires convincing the political and administrative leadership. The only movement so far has been the Kerala government order in late 2019 that spelled out due process for declaring brain death in patients who were not organ donors. Perhaps the way forward is for different components, or perhaps the whole legislation, to be passed by individual state legislatures through focused advocacy, since health is a concurrent constitutional issue. India is a common law country, and a major route for reform is through case law. As the state high courts and the Supreme Court answer issues brought to them, they may go on and make laws, especially if there is no corresponding act of parliament. The views of the Supreme Court of India on end-of-life care have evolved as enunciated through three major judgments, the last of which was delivered in 2018. In the Common Cause judgment, the Supreme Court of India confirmed the constitutional right to regulate one's own treatment, including refusing it even if it were to cause one's own death. They affirmed the validity of an advanced medical directive and withdrawal of life-sustaining treatment. However, they were unable to bring themselves to trust in the good sense and integrity of the ordinary citizen and the doctors. They prescribed an impractical procedure, as a result of which this path-breaking judgment became unimplementable. Attempts are being made to rectify this situation. Over the past decade, guidelines have been put out by professional bodies like the Indian Society for Critical Care Medicine, the Indian Association of Palliative Care, and hospital systems like the Manipal Hospitals Group and the All India Institute of Medical Sciences, New Delhi. The most recent is the Do Not Attempt Resuscitation Guidelines from the Indian Council of Medical Research. Both the All India Institute of Medical Sciences and the ICMR documents focus on empowering and educating the patient and family to withhold inappropriate life support treatment at the end of life. Quality end-of-life care has also been mandated by the National Accreditation Board for Hospitals and Healthcare Institutions. However, implementing these guidelines depends mainly on the awareness of the individual doctor. The medical community as a whole has yet to realize the importance of providing appropriate end-of-life care. Inappropriate and excessive treatment at the end of life fuels conflict. Doctors need to realize that if this provokes litigation, judges are likely to ask if acceptable medical standards were followed and will look to published professional guidelines. Worldwide, the bulk of cases against doctors for end-of-life care are for unwarranted treatment. There needs to be a concerned effort to bring discussion of death and dying into the mainstream media. We believe the best way to do that will be advocacy for the advanced care planning and wide use of the advanced medical directive. And the palliative care community needs to take this on as a major responsibility. Although the mandated procedure for advanced medical directive is cumbersome, at least it is now constitutionally valid and legal. The West, especially the USA, has over 5 decades of experience with these instruments, and there are very, very few instances of misuse. As more and more people make the effort to discuss their own wishes within their families and put their plans down on record, this will become a virtuous circle. Eventually, the government and judiciary will see the logic of making an advanced care planning and an advanced medical directive easy to document and implement. In the future, we can aspire to a quality of death that matches the best in the world. This must include free home palliative care, hospice admission when required, an actionable advanced medical directive, and a system that targets a death as free as possible of pain and other distressful symptoms. A comprehensive end-of-life care legislation has to enable this and can do so while simultaneously reducing medical expenditure. It is our fervent wish that Elicit, the End-of-Life Care for India Task Force, will be at the forefront of these efforts. Thank you.
I'm Dhani Mehta, the co-founder of the Vidhi Center for Legal Policy, and I've had the opportunity to work on issues related to end-of-life care for the last 5 years. So I'm very happy to be talking on this occasion about some of the legal issues that surround end-of-life care in India. What I thought I'd do is divide my talk into two parts. The first, where I discuss what the position of the law is currently, as well as what some of the key rights and principles and obligations that are involved. And in the second part, I thought I could spend a little bit of time talking about why practice in India around end-of-life care might diverge a little bit from the theory, and what healthcare professionals should do in order to ensure that they act in an ethically responsible as well as legally sound manner. So let me begin by talking about what the position of the law currently is. And as everyone probably already knows, the key judgment on end-of-life care in India is Common Cause versus the Union of India, which was handed down by the Supreme Court of India, a 5-judge bench of the Supreme Court, on the 9th of March 2018, so almost 4 years ago. There are some key things that this judgment says, some really landmark rights that it's recognized, and some important advancements that it's made to the field of end-of-life care in India. So the first is that the judgment recognizes that the right to die with dignity is an integral aspect of the right to life itself, which is protected under Article 21 of the Constitution. Now, this sounds like an important, lofty principle, but what does it mean in practice? So the court has spelled that out as well, and there are two things in particular. One is that there is a right to refuse medical treatment as an extension of one's right to bodily autonomy and privacy. So if there is a patient who is able to exercise healthcare decision-making capacity, to understand the consequences of the information that they have been given, to take an informed decision, and if such person refuses treatment, including life-sustaining treatment, then that right must be respected. So medical professionals should not be providing treatment to such a patient against their wishes. And in fact, they might even be criminally liable for going against their wishes and continuing to provide treatment anyway. The other important aspect of this judgment is that it also recognized, again, as an extension of the right to autonomy, privacy, and dignity, the right to execute an advanced medical directive. So the judgment finally accepted that advanced medical directives are legally valid documents and that they should be recognized in a healthcare setting. I think, again, as most people probably already know, through an advanced directive, a patient can, or or any person really, you don't have to be a patient at the time at which you decide to make an advance directive, a person can state that they don't wish to be given life-sustaining treatment at a certain point in the future, and at that point, at a point when they might not be able to take an informed decision on their own. So they might, be in a coma, or they might not. Or withdrawn from such persons. Again, the answer of the judgment is in the affirmative. So you can withhold or withdraw any life-sustaining treatment from someone who is unable to take an informed decision and who has not made an advance medical directive either. And the judgment has laid down a detailed set of guidelines that should be followed while withholding or withdrawing life-sustaining treatment. So this is the core of what the judgment says. I mean, this is the theoretical and substantive core of the legal position on end-of-life care in India. Now the procedural bit, so the court's guidelines, they're quite detailed, and if anyone is interested, they can look at paragraphs 191 and 192 of Chief Justice Deepak Mishra's opinion in Common Cause, but I'll briefly summarize them here. So what the judgment says, and this is both for giving effect to an advance medical directive as well as withholding or withdrawing life-sustaining treatment from someone who may not have made an advance medical directive, is that a three-step process needs to be put in place before such life-sustaining treatment can be withheld or withdrawn. Now, what does this three-step process involve? It involves first a preliminary opinion from an internal hospital medical board. So a group of experts must get together, certify that a person is terminally ill, and that withholding or withdrawing life-sustaining treatment would be appropriate and beneficial and in that person's best interests, and provide that preliminary opinion. Once this opinion is provided, this must be confirmed by an external board that has to be constituted by the concerned collector of that district. And again, that board must consist of medical experts. Now, once that external board also agrees, this decision must be conveyed to a judicial magistrate of the first class, who will then have to go through all the relevant documents, visit the patient and family members, satisfy themselves that everything is in order, and then certify that the treatment may be withheld or withdrawn. Now, it is this procedure that has caused some divergence in the practice of end-of-life care in India, because as healthcare professionals will know, this is an impossible procedure to implement in practice, simply because decisions in critical care settings have to be taken quickly, rapidly. There is no time to go through a three-tier process like this. And more importantly than that, the boards that are required to be set up by collectors haven't been set up so far. So even if we wanted to follow this procedure, there isn't someone we can approach at the moment. Even judicial magistrates who have obligations under this judgment are unaware of this fact, and therefore will not be able to act in the appropriate manner. So what should healthcare professionals do in a situation like this? I mean, on the one hand, if they fail to withhold or withdraw life-sustaining treatment, even though it might be in the patient's best interests, they are in violation of their duty of care to the patient. And at the same time, there is a worry that if they don't follow the procedure that the court has laid down, they might be opening themselves up to legal liability. So what's been done in the interim is that hospitals like the Manipal group of hospitals, as well as the All India Institute of Medical Sciences in New Delhi, have come up with a set of internal guidelines or policy documents or standard operating procedures that set out a somewhat modified procedure from that prescribed by the Supreme Court but one with even more safeguards and checks and balances than the Supreme Court has suggested. So these are publicly available documents that can be accessed by anyone who wishes to read them. So the Manipal Group of Hospitals end-of-life care policy is called Blue Maple, and the AIIMS end-of-life care guidelines are available on their website. So it will be very useful for healthcare professionals and hospitals who are interested in implementing an ethically sound and responsible end-of-life care procedure to have a look at these guidelines. So these guidelines are primarily based on best practice around the world, as well as practice that is agreed on by professional medical associations in India. They also require treating physicians to consult with other experts, other people in their treating team, to make sure that the conditions for withholding or withdrawing any treatment are met, to communicate this decision appropriately to relevant family members or friends or whoever else is regularly attending to the patient in question, to document all these decisions appropriately. There are lots of different forms that these guidelines prescribe for various purposes. And finally, to ensure that their decisions are overseen by a hospital end-of-life care ethics committee. So there's a lot of different kinds of safeguards that are in place. It's an entirely ethically responsible procedure that these professionals and hospitals are administering and implementing. And in fact, this has been confirmed even by the guidelines issued by the Indian Council of Medical Research on do not resuscitate or do not attempt resuscitation. So in addition to withholding and withdrawing life-sustaining treatment, there's also a process that medical professionals can follow as far as do not resuscitate orders or the administration of cardiopulmonary resuscitation goes. And again, in all of these documents, the guiding principle is that doctors must act in the patient's best interests. Their medical opinions must be confirmed by other experts in that field. All of these decisions must be clearly documented and recorded. Wherever the patient is capable of exercising their healthcare decision-making capacity, that must be respected. And there must be checks and balances in case of disputes or a difference of opinion between the treating team and family members. There must be an end-of-life care ethics committee that can step in and help resolve the situation. And decisions must be taken through a process of shared decision-making between medical professionals, as well as the patient's family members and or other close friends. So currently, the status of what end-of-life care in India is, in my opinion, what the best medical practice around this is in India. And as I said, that's currently embodied in these guidelines issued by the Manipal Group of Hospitals and AIIMS. There are a couple of don'ts that it's important to keep in mind when talking about end-of-life care. So the practice of discharging patients against medical advice should be entirely avoided. And even if patients refuse medical treatment for whatever reasons, financial or otherwise, it's an obligation on medical professionals to ensure that they receive the appropriate comfort care, even though other treatment may be withheld or withdrawn. I'm going to end now by just giving you an update on what steps are being taken to change the law in this regard. One, an application has been filed by the Indian Society of Critical Care Medicine in the Supreme Court of India to modify the judgment in common cause. So essentially to ask for a revised procedure from what the court laid down in that judgment. That case is currently pending in the Supreme Court. The Health Ministry is supposed to convene a meeting of all relevant stakeholders. That hasn't happened yet. In addition to that, organization, the Vithi Center for Legal Policy, in collaboration with the End of Life Care in India Task Force, has drafted a model bill around end of life care. So again, for those of you who are interested, I would urge you to read it on Vidhi's website, and put your efforts behind any advocacy, any efforts that you can make to persuade state governments or members of parliament to bring about a sound legislative framework on end of life care. That really is the need of the hour. So that's really where we are at the moment in terms of legal developments around this issue. Thanks very much.
Please go ahead, sir.
Hi, everyone. We are going to have a panel discussion now on withholding and withdrawing life-sustaining treatment in patients with critical and terminal illness. Welcome to this panel discussion. This area of clinical medicine on withholding and withdrawing has several conundrums and controversies and decision-making challenges. It is at times legally unclear, and many describe this area as shades of gray. Here today, we have 4 eminent faculty who will be panelists for this panel discussion. And all of them have made original contributions to the topic that we are discussing, and probably will help us in lightening these shades of gray and will help in making it more transparent. So in today's panel discussion, we have Dr. Rajkumar Mani, who is the Director of Clinical Services at Yashoda Super Speciality Hospital, Kaushambi, Delhi. Dr. Roop Gursahani, Senior Consultant Neurologist at PD Hinduja Hospital, Mumbai. Dr. Nagesh Simha, Medical Director, Karunashraya Bangalore Hospice Trust, Bengaluru. Dr. Dhwani Mehta, who is a lawyer, who is a Senior Resident Fellow, Vidhi Center for Legal Policy, Delhi. I heartily welcome all the panelists. Thank you for joining today. So starting with the panel discussion, my first question is to Dr. Mani. Sir, how will you explain the terms withholding and withdrawing to the large uninitiated participants who are viewing this panel discussion?
So simply stated, withdrawal, for instance, is removal of an ongoing, continuing life support. By that we mean anything that sustains an organ function artificially. Now this happens when 2 conditions prevail. One is that the considered opinion of the professional caregiver, that is doctors, is that the ongoing treatment is non-beneficial or inappropriate, leading to harms outweighing benefits, possible harms outweighing possible benefit. This combined with either the patient directly or through an advance directive, or representing the patient, a surrogate or a next of kin, or a significant other in the next friend, in an informed manner, make an informed choice of not having this modality of life support continued, or putting it another way, refusing the ongoing life supporting modality. So this is withdrawal, and withholding is not initiating a life support modality at all. So the first one is interrupting an ongoing support, and withholding is not initiating or starting at all.
Thank you, sir. And I would like to take further from the same explanation that what you give. So what do you think is the ethical equivalent to withholding versus withdrawing? Because there's a lot of doubts in people's mind about an ethical or a meaning making of withholding versus withdrawing. What is your perception about them?
You see, on the face of it, it would seem that withholding is easier to accept because it's something passive. It's an omission to do something. And whereas withdrawal is something active, you're removing something, and death may be attributed to the act of removing that ongoing support. However, if you look at it more deeply, or you follow what is the logic or reasoning given by Beauchamp and Chelres in their seminal book, they are ethically equivalent because both of them don't stand by themselves on the ethical question. The premise is they are an artificial support is not beneficial or doing harm. Harms outweigh benefits, as we mentioned. So that is the premise, the basis on which both stand. So they are equivalent. If we were to imagine that they are not equivalent, then what happens? We wouldn't have the option to put a patient on a trial of intensive care. We would either take a stand of withholding at the outset, which may lead to undertreatment, potential undertreatment in a proportion of patients. And if we should give a trial of intensive care and not have the option to withdraw, then it would lead to overtreatment and an undignified death, which is what we want to prevent with these two procedures.
Right. Thank you, sir, for that answer. Next, moving on to Dr. Simha. Do you think public is aware about these concepts of withholding and withdrawing? And if not, what we should do to disseminate this knowledge to the public?
My first question is, when you say public, whom are you talking about? If we include the medical profession as public, if we include the legal profession as public, and of course, the public, that is the non-medical, non-legal people. I think first we need to educate the doctors and the lawyers, because I think they are very, very important people in this whole context. The second thing is that, talking about death is considered to be inauspicious in our culture, but it might be a good idea to look at the concept of what we call as dinner with death or a death cafe. How do we get people to talk about it? And the focus should initially be on senior citizens, homes, the geriatricians, and now there are a lot of places where senior citizens tend to live together, and they could be a focus of a targeted focus on educating them. Of course, we need to use the help of the social media and perhaps look at starting off a helpline that is available. The other very important thing is that we need to train our counselors, those who are dealing with these sort of things, in what exactly this withholding, withdrawal, the ethical aspect of it, which my friend Raj so very nicely said, and how do you actually approach. So in a way, communication skills, of course, this needs to be also certainly taught to the doctors. And very importantly, finally, is that this aspect of end-of-life care and all that goes with it has to be included in the curriculum for medical students, for nursing students, and particularly the postgraduates, of all specialties, but particularly those which deal with it, like, critical care or nephrology, neurology, and so on and so forth.
Right. Thank you, sir, for that answer. Now, the next question is to Dr. Dwani Mehta. As an officer of the court, can you tell us how is the Indian judiciary presently handling or might handle a case of withholding and withdrawing if it is brought to the court's attention?
Right. So I think my first response there is that if a case like this comes to court, then that means something hasn't gone right. And obviously there's been either a disagreement between the patient's relatives and the treating team, which hasn't been resolved appropriately. So let me sort of start by saying, I suppose the approach of the court would be first to, and I think, as I've mentioned in other fora as well, that the court is likely to investigate whether what happened medically happened in accordance with responsible medical practice. So assuming that the case has been brought by, say, a patient's next or relatives against the opinion of the medical team in question, the court is likely to examine, well, what was the procedure that was followed? Was this in accordance with professional medical guidelines? Did the treating team consult the appropriate experts? It's unlikely that the court will go into the actual merits of the case. So the court is not supposed to sit in judgment over whether the treatment in that case was beneficial or not beneficial. What the court will be concerned with is whether the appropriate procedure was followed. So, this is what courts do. This is a judicial review, not a merits review. So it doesn't go into the substance of the actual decision, but it sees whether the decision has been taken appropriately with the right safeguards. And so if the appropriate safeguards have been taken, doctors are unlikely to be held liable. So, for example, if they have ensured that they consulted an appropriate number of experts in determining whether the treatment was beneficial or not, if they ensured that they shared this decision and communicated this appropriately to the patient's relatives and family, if they recorded this decision, if they documented everything that they were doing as part of this process, and if they ensured that this was done in accordance with whatever the latest guidelines are that have been issued either by the Indian Society of Critical Care Medicine, the Indian Association of Palliative Care, as well as the Indian Council of Medical Research, as far as do not resuscitate decisions go, then doctors are likely to be not held liable for anything that might have gone wrong or any dispute that might have arisen. So this is what I think the approach of the courts is likely to be. And the main point to remember here is that courts will, it's legally valid to withhold or withdraw life-sustaining treatment. So that will be the starting point of the court. It will then only be concerned whether the appropriate procedure was followed or not.
And there is a likelihood that they will rely on the experts and the documents created by the expert.
Absolutely. So both the Blue Maple document that's been created by the Manipal Group of Hospitals, the end-of-life care guidelines that AIIMS New Delhi has issued, the guidelines issued by the Federation of Indian Chambers of Commerce and Industry, as well as I mentioned, the ICMR guidelines on do not resuscitation. These are all existing professional guidelines that exist with a clear procedure and pathway laid out. So the court is likely to consult those and rely on them in determining whether the appropriate medical practice was followed or not.
Right. Thank you, Dr. Mehta. Now I'm going to slightly a notch up difficult questions to Dr. Gursahani. So in few high-income countries, especially some of the Western countries, the concept of medical aid in dying is coming up. Could be in some certain neurological conditions also. And it's becoming popular and acceptable, and parliaments are passing them. So can you tell us how it might relate to the topic that we are discussing today? And do you think sometime in the future, MAID may become part of a clinical practice in select clinical conditions?
Medical aid in dying is a difficult topic. It's something that euthanasia has been covered under the term euthanasia, active euthanasia, and so on. And in a sense, at least, it's almost explicitly forbidden at the moment in our legal system. Having said that, one of the worries that patients who have neurologic conditions have is that, unlike say cancer, where the end stage is not very long, in neurology it can be extremely long and personhood is lost. So neurology patients often think of undertaking assisted dying or medical aid in dying or physician-assisted suicide, various terms that I used, at a stage when they still have control. Now, as far as India is concerned, I think we have to establish jurisprudence, procedures for all the basic building blocks. We have to go through the basic stuff like foregoing life support. We've got to go through advanced care planning. It's only when our legal systems, even when our doctors get comfortable with all of this, that we will eventually come to medical aid in dying. And remember that countries that have medical aid in dying are established democracies. Take, for example, the Netherlands. It's been a democracy for something like 300 odd years. You all know of European friends who will stop at a red light at 12 in the midnight. You know, they will follow laws and rules. We are not there yet, either in terms of our civic and sense and our ability to control processes, as well as the understanding that will go into something like this. So if you are asking me, is medical aid in dying going to be possible in India maybe 30 years from now? That's my guess. Unless Dhwani wants to say that it's going to be shorter than that.
No, I was going to say it will be longer given the pace
Longer,
that
yeah.
the courts proceed.
Yeah, probably, yeah. You're very optimistic, Dr. Sahani.
30 years is optimistic. Okay, fine.
Yeah. Okay. Thank you, sir. Thank you for that clarification. Now, going back to Dr. Mani, sir, as an intensivist, what are the specific challenges that you face from your peers, other healthcare providers, or the hospital administration when you are facing a situation where you have to withhold or withdraw a life-sustaining treatment?
I encounter huge stumbling blocks. And, there are two surveys, one locally done in India, another of Southeast Asian countries. Surveys of intensivists, as asking them what is the barrier, in their opinion, to these decisions, withdrawal, withholding. I mean, it's almost always, they say it's the law, it is the institution where they work. Now, why has it come about? Because I think, the law in the country has reflected the misgivings in the public mind without resolving the misgivings. Okay. Although in basic principles, they have conveyed that there is autonomy, there is a right to choose, and therefore there's a right to refuse anything. And therefore, constitutionally, it's valid. But the prejudices and mindsets are reflected in the procedure. So whenever there is a rider in the procedure, which makes it complicated, then there is always a doubt in the minds of the physicians. On the one hand, if it gets past them, then it gets stuck on the administration. And there are, in every hospital or institution, there is a legal advisor whose mind is mired in the mindset that prevailed before intensive care came into force, okay, before the scientific advances took place. So you face huge barriers, but they are not barriers to be worried about or be afraid of. They are barriers to, as in a race, okay, in a sort of race where you have to jump many barriers. So when you do that, you feel empowered. And the situation eases. The ecosystem develops a culture where it is easier and easier. You must have seen it in your own environment in Manipal, having published a policy in Blue Maple and having worked at it day after day. When you do that, you chip away at the defenses. And then the rationality prevails. So what I have encountered is I have changed many hospitals. In every hospital, initially, whatever barriers I encountered, they gave way as we started to do them, because it seemed so natural to allow a natural death to take place. It seemed so natural to take an appropriate decision, an ethical decision, because all the stakeholders involved feel more and more comfortable. In fact, your quality of relationship with the families improves several notches. So I believe, while it is difficult, it is a challenge worth accepting. It's a cause worth championing.
Thank you, sir. Thank you. My next question is to Dr. Sima. So, sir, you are one of the key persons spearheading the ELICIT in India. What work ELICIT is doing or has done with the legislators, law and policy makers of the country to help people in India to have a better end of life care?
I must say that as far as this work is concerned, COVID has been a terrible dampener. Initially, we had worked with a few of our legal friends and in fact come out with a draft bill, and we were discussing about that. And then, of course, the Supreme Court initial judgment was that every time you needed to withdraw, you had to go to the High Court. Then the subsequent judgment came that local committees have to be formed, and of course, they accepted the legality of the Advanced Medical Directive. We were asked, I mean, the constitutional bench instructed the government to call the stakeholders, and we were all set. In fact, I was shopping for some toiletries to leave for Delhi the next day in the morning, and my most eminent and good friend, Dr. Dhwani Mehta, calls me and says, he says, Nagesh, forget about coming to Delhi because the government has just cancelled the meeting, and we still have not been able to meet with the government. In the meanwhile, with the Center for Legal Policy with Dr. Dhwani has put up on their website a draft bill which has kind of taken care of all the possible worries, doubts, or whatever. We've had a fair number of consultations, and I think now with the COVID probably kind of going down, we are in the process of discussing amongst ourselves that we need to revive this, probably go back to the court, etc. I think it would be unfair on my part to comment on these things. I think Dhwani is the ideal person. But of course, we have been doing a lot of other work. We've worked with the ICMR. We've had the privilege of working with you, Naveen. And perhaps rather than just asking questions to us, you might also want to give your opinion, because you are as much of an expert as any one of us. And let us hope that we're able, the environment in the country at this point of time is not that conducive to be discussing these morbid subjects, but we are definitely going to be at it.
Yes. And thank you for that response. And probably my comments would be that we want to demonstrate in our workplace that it is possible, it is doable. And right now I have a PhD student who is doing only on ICU palliative care for the next 3 years. So we want to focus on those work that we are doing, try to bring out as publications that what we did. One of the publications that we brought out was what we did for end-of-life care for COVID patients. This is the first publication in India which had 50 patients where end-of-life care was provided in COVID. So we want to now bring out not just talking, but evidence in terms of how this engagement has happened and how this collaboration and how it could have the transformative role. Yeah. So thank you. Yeah. So my next question is to Dr. Mehta. It is probably a follow-up to what I spoke to Dr. Simha. So Simha, I asked about from a legislative purposes, from a policy maker. But Dr. Mehta, can you tell us, are there or will there be any judicial reforms before any legislation that might come that could facilitate withholding, withdrawing as an acceptable clinical modality of treatment in India?
So I'd say that judicial reform is already there in practice. I mean, in theory, I suppose. Yeah, that's what the common cause judgment is. That judgment has two reforms that are intended at facilitating withholding and withdrawal of life-sustaining treatment. One, it grants legal recognition to advanced medical directives. And two, it states that no healthcare professional will be criminally liable for any withholding or withdrawal. So the path for this kind of withholding withdrawal has already been laid by the judiciary. Now the question is, what judicial reforms can we expect in terms of modifying the procedure that the court has laid down and which has proved to be difficult to implement in practice. Now, as Dr. Simha mentioned, the Indian Society of Critical Care Medicine has already filed an application to modify that procedure, and that is currently pending in the Supreme Court, and we hope that we can get the court to hear that matter again And hopefully that will result in the health ministry convening a meeting of stakeholders and everyone arriving at a consensus on what a reasonable modified procedure can look like. In the meantime, there is always scope to, get the judiciary to weigh in on this by either individual doctors or patients or hospitals themselves filing an application before the court explaining why it's currently difficult for them to carry out their medical practice, or why for patients it is difficult for them to actually realize their right to refuse life-sustaining treatment and die a dignified death. And maybe in an individual case like that could trigger the judiciary to retake, to take up that other application that's already been filed again, and we might see some movement on that front. But I just wanted to make it clear that as far as the law is concerned, it's valid. I mean, that judicial reform has already come into place. It's legally valid to withhold or withdraw life-sustaining.
Thank you for the clarification. And I think for many of the participants for this panel discussion, I think this makes it very clear and this drives the point, and that's very important. My last question in this discussion, again, it's a bit of a difficult question to Dr. Gursahani. Can you explain to our participants about the concept of donation after circulatory death, what we call it as DCD, and how does it relate to the topic that we are discussing today, and when it again might become a reality in India?
Okay, so most of us understand that organ donation needs it has to follow the dead donor rule. The donor has to be dead. Now, if you're looking at donation after brain death, we follow the death by neurologic criteria standard, and that's fairly well established. So you can declare brain death depending on the condition and so on. And once you have consent and so on, once you've fulfilled all the procedures, you can proceed to harvest organs. Now, what happens if somebody has very severe neurologic damage, which precludes any kind of return to normalcy, where perhaps the patient, the victim in advance had said that this is not a kind of survival that they would want, but the surrogates are in agreement. Well, in our situation, these are patients where we are, in any case, often proceeding with foregoing of life-supporting treatment, and we are at some point going ahead and doing what is called as palliative extubation. So you extubate, and the patient then, over a period of time, either passes away or stabilizes at a point at which they can be moved out. Those patients who would not survive are candidates for what we would call donation after cardiac death. This means that the palliative extubation takes place in the OT after due processes are followed. Once the extubation is done, the heart stops after a certain period of time. After the heart stops, that's when the clock starts. And different jurisdictions in the West have different periods of time. It's anywhere between 2 and 5 minutes. The usual is about 3 minutes. 3 minutes, heart stoppage, and the harvest team actually springs into action. And they begin to harvest the organs. Originally, it began with kidneys, but now, given procedures and so on, it is now possible to even harvest the heart. So where is India on that? Now, you can understand, when I spoke earlier about MAID, we need, again, for DCD, we need some building blocks to be done. We need foregoing life support to have its procedures in place. We need people to be used to doing that. Once we have that, then we'll be able to proceed with DCD. So for that, I think my time horizon is a little shorter. And Dr. Mani, Dr. Simha and I are part of a team that has, from the transplant community side, written up a kind of a concept paper, which is, I think, about to be published in at least a couple of journals, which will tell the broader community the modalities of doing this. Whether the judicial and the legal part of it will follow, well, that will obviously take a certain amount of working on. But I think that is a doable project.
Yes. Thank you so much. I know it was a difficult question, but both the questions that I asked was slightly off the track and probably with a futuristic view. And thank you for answering both of them very well. We come to the end of the panel discussion. However, we have few more minutes for the participants to ask us any questions. You can type your questions in the chat box, or you can unmute yourself and ask to the panelists directly. I think, Gaurav, we can stop recording. Hi, everyone. I think there were few questions in the chat box, and some of these are answered by the panelists, and some I would like to take. One is by Dr. Kakani. The question reads as, do we offer DNAR in advanced cancer patients who theoretically may be benefited by some newer but expensive drug which patient cannot afford? Dr. Mani, can I ask you to answer this question?
You see, DNAR does not preclude instituting some reasonable curative treatments. Okay, you have to take it separately, whether that expensive medication is justified in the given clinical scenario, and that has to be a consensus between treating physicians. DNAR only means you've taken a deliberate decision not to do CPR. That's all. Okay.
Family could still choose not to escalate a treatment or to withhold a treatment. So these are two different things that are happening. So I don't think one is conditioned to another. The next question is to Dr. Dhwani Mehta from Sonalini. The question reads as, doctors might not be held liable by the court, but it's a matter of trial which is pain process. How would you like to answer that, Dr. Mehta?
Sure, Dr. Naveen. Sorry, I apologize for some of the disturbance at my end. There's some construction work going on here. I have answered this briefly in the chat box, but I'll just repeat what I've said there. That I mean, I'm not entirely sure this is a question. It is a comment on the judicial process, and I fully agree with that comment. It is, the punishment, the trial is the punishment, really, not the actual. I mean, in the process of having to go through litigation, I understand is incredibly tiresome and painful. But it's important to note that, as far as I'm aware, there, for doctors like Dr. Mani and Dr. Roop and Dr. Nagesh, who have been practicing this for several years, they have never faced any litigation about the kinds of withholding or withdrawal decisions that they've made, and it's because they followed the ethically sound principles that we've discussed in this talk so far. So, as I said, I mean, I think if you want to avoid I understand that you may not be held liable, but if you want to avoid the actual process of going to trial, I mean, there's no quick fire short solution to that. Anyone and everyone can take you to court, and there's nothing anyone can do to stop that. But I mean, as a matter of practical legal advice, I mean, don't implement withholding or withdrawing if there is a dispute that you haven't been able to resolve with the patient's next of kin or other family, friends, or relatives. So if you can see that that there is a dispute ongoing, that this is not something that you've been able to resolve even after multiple rounds of shared decision making or referring it to your hospital's ethics committee, then just don't do it. And if you feel strongly about doing it and you think it's important that in the patient's best interest that that treatment be withheld or withdrawn, then make an application to the court. But then, of course, you will have to go through the judicial process, but it will be you who's initiating the litigation as opposed to a disgruntled relative filing a case against you. So that's the practical advice there.
I would like to take one last question. I know maybe we are.
Naveen, if you permit, I wanted to ask Dr. Mani something. I know in the
okay, please go ahead.
Yeah, Dr. Mani, I want to ask you. Firstly, excellent talk on withholding and withdrawing life support. So there was a discussion in the chat as well about, is it just, withholding is important, but in my mind, withdrawing is equally important. And I saw a discussion between you and Dr. Roop. So can you throw light on this? I mean, isn't that equally important, withdrawal as well, especially in the context?
If you allowed only withholding and not withdrawal, or you are shy of withdrawal, that means a job half done.
Right.
All right. And see, the idea is to provide dignity in death. And the idea is also not to undertreat. Okay, this is a fine balance which an intensivist always has to tread, because he's practicing a high technology medicine. And that's his forte. And you can't hold that back when you think there is a half a chance. You see, that's the whole problem. There is a gray area of decision making, which is the bulk. Okay, the clear futility and the clear curative, between them there's a huge gray area. What do you do with it? That's why the TMT, time limited trial, TLT, time limited trial comes into play. And that's what we are most of the time doing. In fact, all the navigation, negotiation indicates only this, that we are traversing a minefield and we are walk carefully. And when we are not sure, we give a trial. In fact, I think there's a recent article in the intensive care medicine where they say every case in intensive care where you put on advanced aggressive treatment is a time limited trial. Every case potentially is a time limited trial. You think you're going to win, and down the road in 3-4 days it dawns on you they are not going to win. Are you going to say, no, I didn't take a withholding decision, and now I'm stuck, I can't take a withdrawal decision?
Right.
So that sort of thing is job half done.
Absolutely.
And you fall into a trap more often than not. Either you undertreat, that not embarking on a trial at all, or you overtreat, and once having taken the road, you can't go back. So as an intensivist, it's impossible to take withdrawal out of withholding.
Absolutely.
Not at all.
Important.
So they are both together. That's why they're always considered together. And if you see, majority of the decisions taken in the advanced countries are withdrawal, not withholding. Because they are giving a trial. There is a bias towards aggression. But you're tempered with the idea that once you are seeing clearly that you're not winning, please take stock again. It's a second chance.
Absolutely, Dr. Mani, because especially in the ICU intensive care context, this becomes very important.
It's not possible there. See, much before the ICU or hospital, withholding is the route. I agree.
And also,
I agree. But majority of people are dying in ICUs. Everywhere the stats are there.
Right.
We are spending 10 times more for the dying than for the living.
Yeah.
In that same age group. That is also a stat. And
as you rightly said, though withholding may be easier to do, it's incomplete unless you also address withdrawal. Okay. Thank you, Naveen. Sorry.
I want to ask the chairperson, how are we doing with the time? Is there time to take questions, or are we?
I think we are way past time, Naveen. It should end at 11. And it's already 11:20 now.
Okay. So from my side, I will close this questions. Thank you.
So thank you very much to all, and it was an excellent session, especially the panel discussion. I think it was very informative. And this topic obviously generates a lot of heat, but also a lot of light has been thrown on the subject. I'll request my co-chair, Dr. Shabbat Jod, to please wind up the session. Thank you, everyone.
Thank you, all the panelists and all the speakers, Dr. Rajmani, Dr. Dr. Sima, Dr. Dhani, Dr. Gursani. Thank you, and Dr. Naveen Salis for his moderation of the panel discussion. It was a very good discussion, and I think the key point here is the physician needs to be educated. So if the physician, a lot of the times, most of the time, the physician does not know what to do. So that is why people are afraid. Thank you, everyone. I think we'll close the session.
Thank you.
Okay, thank you all.